Yeah. A very good afternoon, everybody. We are final year students of Usmania University College of Law, and we are very proud to have a very first podcast from our end. So today we have with us Advocate Arvinda Rao Punjala. So Advocate Arvinda Rao Punjala holds a special distinction in matrimonial and criminal law, and is also a guest lecturer at various law colleges. And today we are specifically going to discuss on the theme of freedom from violence, legal provisions for safety and security of women. And in this, the sub theme that we are going to discuss is related to pregnancy related violence, a legal perspective. So, welcome, sir. Can you?
Thank you for inviting me, and hello to all. Myself, Arvinder Rao Punjala, advocate and practicing in all Hyderabad courts. I am here to put the legal perspective on legal issues related to women to the best of my knowledge. I shall bring awareness on this subject through my knowledge.
We too will be asking questions which is in mind of common people, those who are not aware of their right.
Yes.
And one by one we too will be
Yes.
asking questions followed by your explanation.
Please go ahead.
Sure. So, sir, as we are going through the laws of the nation, being a developed society, so how does Indian law recognize pregnancy related violence within the framework of constitutional right?
Right. So, when you say does Indian law recognize pregnancy related violence within the framework of constitution rights, I would say yes, we have various laws. Okay, in the constitution, it is only the matter of awareness. And speaking about pregnancy related violence, Indian law indirectly but clearly recognizes this issue through constitutional interpretations under various articles, whether it be Article 21, that is the right to life, or Article 14, that is right to equality, and Article 15, duty of state to enact special laws like various states have done to the Domestic Violence Act.
Thank you, sir.
Thank you, sir. So, specifically taking into consideration the society that we have, why do you think, despite the legal frameworks that we have, despite the legal protections, why do you think pregnancy related violence and pregnancy related cases are still underreported in the country?
Basically, I would like to repeat again that the Supreme Court has repeatedly clarified that the right to life isn't just for survival, it includes dignity, bodily integrity, and personal autonomy. So, when a woman is forced to continue pregnancy, denied medical care, or coerced into sterilization, or subjected to violence during the pregnancy, it is just not a private issue. It becomes a constitutional violation of law. And when you say that why the society is not accepting this, it is just due to lack of awareness of these laws among the women of our country.
So, with your permission, we would like to move into further question. So, sir, as we are seeing the development in this world and development in the matrimonial laws and medical laws, as we have seen, government is more enthusiastic of passing such laws which regulates the pregnancy, termination, surrogacies. So, we would like to shed light on the Medical Termination of Pregnancy Act, and it's a provision like how it is enacted with the objective to protect the right of the woman to choose.
Yeah, as you know, all the laws are basically enacted for the protection of the section of people for whom it has been enacted. In this case, it is for the women, and for their well-being, it has been enacted and passed by the Parliament, and there are so many laws. But here, coming to this particular law which actually protects women against pregnancy related violence, I would say that very clearly reproductive autonomy in India flows directly from Article 21. Even though the Constitution doesn't use the exact phrase, in a particular case where Suchita Srivastav versus Chandigarh administration, the Supreme Court made it clear that women's right to make reproductive choices is a part of their personal liberty. That includes the right to decide whether to continue or terminate the pregnancy. And more recently, in one more case, in 2022, X versus Principal Secretary case, the court expanded abortion rights to even the unmarried woman. So, it is not just for the married woman, even the unmarried woman can go for abortion, making it clear that reproductive autonomy cannot depend on marital status. So, today reproductive autonomy is firmly rooted in the Article 21 and supported by equally and non-discriminatory principles under Articles 14 and 15.
Thank you, sir. Thank you, sir.
Okay, thank you, sir. So there is also a section of the society, specifically the minors and who are the people who are the survivors of sexual violence. So do you think they are adequately protected under the abortion laws that we have currently, or any other law for the time? Do you think they are adequately protected right now?
So, I just answered that. Even the unmarried women, okay, they have rights. Okay, they can go for a termination of pregnancy, while certain matters where the children are married or children due to the result of certain criminal acts like rape, okay, even if the pregnancy is being found, so they can have the court's permission to terminate that pregnancy.
Sir, my question is, after passing of the Surrogacy Act,
Yes.
so how does the law address the coercion, exploitation and economic pressure in surrogacy arrangement? Like in the Surrogacy Act, there is a provision for the altruistic, but relation to the altruistic surrogacy mother is not been defined, sir. So they are subjected to coercion, exploitation and economic pressure. How does law arrange for such provisions, sir?
Yes, we have this Surrogacy Regulation Act of 2021, which actually permits altruistic surrogacy for non-commercial profit. Okay, only Indian citizens can commission surrogacy, protect surrogate mothers from exploitation and ensure informed consent. Okay, basically the definition of this surrogacy is arrangements where a woman carries a child of another person or a couple. So, we see in our society there are so many couples who are not able to bear children. So, they would take a help of this particular law, surrogacy, whereby other woman will carry the child of them, and after a stipulated period the child will be returned to the actual parents who are the cause of this particular arrangement. But the government is very sensitive about this particular act or this particular surrogacy thing, that it should not be exploited by the seekers, so that the women who are getting exploited should not be at receiving end. So, they have made this particular act, Surrogacy Regulation Act of 2021. Okay, it should not be for commercial benefits. So, non-commercial profit benefits, somebody can undertake surrogacy and able to get a child.
Whether surrogate mother reserve the right to terminate the child, as we have discussed in Medical Termination of Pregnancy Act?
See, we just discussed in the first thing that basically pregnancy is at the will of the mother who is bearing it. We have the laws enacted, and even the Supreme Court in different cases has said, even in a rightful marriage where there is a husband and wife and rightfully they have planned for a child, and in between the mother wants the pregnancy to be terminated due to whatsoever reason. So, basically this is a right bestowed upon the mother by the constitution of our country.
So now one of the most paramount things in surrogacy is the health of the mother who is going to give birth. And so what are the specific legal remedies that are available if a surrogate mother's health is deteriorating as per the Act?
So, basically surrogacy is out of choice, and the person who is taking care of surrogacy for a newborn, okay, they should be taken care, their health should be taken care by the people who are actually coming forward for this surrogacy act. Apart from that, even in the worst case scenario, due to whatsoever reason, the health is deteriorating, the pregnant woman who is hired or arranged for surrogacy, if her health is deteriorating, it is the call of the mother, the woman, to actually go for termination of pregnancy.
So, sir, I have one question, whether the banning commercial surrogacy reduces exploitation or does it push it underground? Like we have witnessed multiple cases of this surrogacy rackets. Recently it was busted in Hyderabad as well.
So, basically the law is designed in such a way to respond swiftly to protect both the woman and her unborn child, and here surrogacy is only permitted, okay, where it is really wanted. There should be no commercial exploitation of women, and the law clearly states that, and we understand that surrogacy should be the last option, okay, for the parents who want to bear the child. They have so many other facilities, and we all understand that after going through all other facilities, they finally come to surrogacy. Okay, you may say that there can be some commercial exploitation on this aspect, but here we should understand that the law does not promote any commercial activity on this particular aspect.
Thank you, sir.
So my question to you is, what legal standards have the courts laid down with regards to consent in a sterilization procedure that is there?
So, when you say that legal standards from the courts, yes, we have some legal standards, and Indian courts have consistently held that informed and voluntary consent is mandatory in sterilization procedures. So, the person should be informed whenever he is going to sterilize. The woman on whom this sterilization process is being done, she should be informed basically. In a particular case, Devika Biswas versus Union of India 2016, the Supreme Court emphasized that forced sterilization is a violation of Article 21, that is right to life and dignity. Consent must be in written form, it should be voluntary and it should be obtained without any coercion, inducement or misinformation. Courts have also required pre-procedure counseling and explained the risk of terminating the pregnancy. Okay. Any sterilization conducted without proper consent is legally void and amounts to violation of constitutional and human rights. The judiciary has reinforced that bodily autonomy cannot be compromised, even under government family planning programs. So, even under the government family planning programs, they should be well aware. The woman who is undergoing that process should be made well aware of the facts.
So, sir, one of the most important aspects today with reference to matrimonial laws and even pregnancy is that of domestic violence, or rather intimate violence in intimate relationships. So, my question to you is, what legal remedies are available to pregnant women when it comes to domestic violence?
Yes, when you ask this question, we have to understand that we are a society where there exists certain violence between the married partners also, and to curtail that, we have certain laws. Okay, the immediate legal remedies will be pregnant survivors of domestic violence can seek immediate protection under this act, okay, including protection orders, residence orders and monetary relief. Protection orders prevent the abuser from committing further violence and or contacting the survivor. Courts can also direct medical assistance and shelter and appoint protection officers to ensure compliance. Survivors may file complaints for emotional, physical and reproductive coercion, distress and seek civil remedies, and also file some cases for criminal proceedings. The law is designed to respond swiftly to protect both the woman and her unborn child, emphasizing safety, health care and access to justice.
Thank you, sir.
So one of the most important or significant mishappenings of a country is female feticide. So with reference to that, with reference to law, my question to you is, what is the legal stance on selective sex abortion? Particularly, what does Indian law criminalize selective abortion?
Yeah, very nice question. We have to understand that India is a culture based country and we are obsessed with male children. So when we say our society, not all the states, but there are some states where we see that they are very choosy about the child. They always want a male child. Okay. So selective selection, abortion is criminalized under the preconception and prenatal diagnostic techniques, that is PCP NDT Act of 1994, which prohibits determining or disclosing the sex of the fetus for non-medical reasons. So many parents, they go to the diagnostic center. Previously, it was open some 2-3 decades back. The diagnostic center were actually telling what was the sex of the child in the fetus. Now it is banned. Okay. The act penalizes doctors, clinics and parents involved in such practice with fines, imprisonment and cancellation of medical registration. So the doctor can lose his license if he is revealing the sex of the fetus. So it aims to curb female feticide, protect the right of equality under Article 14 and prevent gender based discrimination by regulating diagnostic techniques and banning sex determination for non-medical purpose. The law makes sex selective abortion a criminal offense while promoting ethical medical practices. So in our country, you have to understand that sex determination tests are banned and people should not be asking or seeking the sex of their unborn child at the diagnostic center. Even asking them, they can be reported to the security agencies. The doctor can report that this particular patient is seeking for sex determination and they can be given legal punishment.
Yes, sir, I just have a follow-up question. So sex determination is an offense currently, as you have mentioned. Do you think this is going to be a stance in India eternally? Which means, is there any time that we are going to see that sex determination can be legalized? Because there are a lot of countries across the world where it is legalized. So do you think any time it may occur that India may legalize it?
So I cannot say that, but with my limited knowledge, I would like to suggest if it is not occurring in India, it is best, because we have our society, which is, I have told in my previous statement, that which wants the sex, they want only male child. So what happens is, when you opt for only the male child, okay, for whatsoever reason, the balance of the male and female ratio gets affected, and already it is showing up. Now the government, after realizing all these things, they have come forward and enacted this particular law. Why do you think the prenatal tests have been banned, the sex determination tests have been banned? That is because the government has seen, has understood that this particular sex determination tests at the diagnostic center is actually causing an imbalance in the overall population of our country. It may be good for the other countries, some other countries where the population is very low, but in our culture, in our country, this does not suit us. I strongly advocate that this ban continues forever.
Thank you, sir. Now we would like to move to further question. So, sir, as we have discussed about the sex selective abortion, sir. So, sir, we discussed about the screening and determination of the test. Now, I would like to emphasize where it starts. Like it starts from where they originally belongs, like the family, the house. Older parents, they create pressure on the newly wed or newly pregnant wife, newly pregnant lady to only give birth to a male child. It is their preferential choice to have only boy. So, whether this preferential choice and pressuring the women for delivering only male child, whether it has any criminal liability?
So, nice question. First, basically you have to understand that you asked me where it starts from. It starts from the greed of the human nature to only wanting for a particular child, a particular sex as a child. So, this greed should be curtailed, and if the humans are not curtailing, the people involved in our society are not curtailing, the government steps in. So, how does the government step in and what does the government do? Yes, the government is here making some laws. Medical professionals are central to both preventing and facilitating female feticide. Those who follow ethical practices, refuse sex determination requests and report violations, help enforce the PCPNDT Act and protect gender equality, they are given preference. Conversely, doctors or clinics who disclose fetal sex, perform sex selective abortions or falsify records directly enable crime and are criminally liable for persecution in courts. And regulatory authorities emphasize that medical professionals having both legal and moral responsibility to uphold the ethical standards, ensure informed consent and resist societal pressure, making them key actors in combating this menace called female feticide.
Thank you, sir. So now I would like to know, sir, whether the current inspection and monitoring mechanism are sufficient to prevent prenatal gender screening and create legal accountability, sir.
Yes, so nice question again. I would say that the current inspection and monitoring mechanisms under this PCPNDT Act exist, but they are largely inadequate. While regulatory authorities can conduct inspections, many clinics operate without proper oversight, and violations often go undetected due to limited manpower. Corruption or poor enforcement is also around. Training gaps among inspectors and inconsistent penalties further weaken deterrence. Effective enforcement requires frequent inspections, strict accountability and public awareness. Without strengthening these mechanisms, the misuse of prenatal diagnostic techniques for sex selection still continues and undermining the purpose of the very act which has been enacted.
Thank you, sir.
So my question to you is, how can law enforcement balance privacy rights of a person with prevention of gender-based violence? So the relation or overlapping between privacy rights and gender-based violence.
So when you say balancing privacy rights and with the prevention of gender-based violence, I would say that this requires targeted regulation without violating personal confidentiality. Okay, authorities must ensure that records are used strictly for monitoring compliance and prosecuting violations while safeguarding patient. Identifying legal safeguards should prevent misuse of medical data, and inspections should follow transparent procedures. Courts have emphasized that the right to privacy under Article 21, as you mentioned, are compatible with enforcing the PCPNDT Act, as protecting unborn girls from sex selective abortion is a legitimate state objective and also a society objective. Proper protocols, ethical oversight and awareness campaigns should help enforce these while respecting the privacy rights of an individual. So, it is the responsibility of not only the state, but even the society and you as the law students to bring some awareness on this enforcement.
Okay. Thank you, sir.
So now, these are one of the concluding questions. So we have discussed a lot about gender-based violence and pregnancy-related violence. So my question to you is, overall, with respect to the reproductive justice that we have, what are certain legal reforms that we need as a society in order to progress ahead?
Yes, as a citizen of India and as an advocate and as a law lecturer, I would say we are doing reasonably well, but much more has to be done in this regard. So, reforms should include clearer definitions of reproductive rights, comprehensive protection against coercion, and a stronger regulation of medical procedures like sterilization and surrogacy. Expanding access to safe abortion, increasing gestational limits in special cases, and ensuring informed consent are critical. Legal frameworks should also integrate protection for good unmarried women and survivors of sexual violence. Effective monitoring, penalties for non-compliance and public awareness campaigns can reduce violations. A right-based approach that links reproductive autonomy to gender equality and dignity with the help of establishing stronger reproductive justice will actually raise its objective in India.
Thank you, sir. Sir, now we would like to know, as being a young legal profession, what roles we can play in advocacy in order to create awareness about these issues, sir?
See, I would suggest that as a young legal would-be advocate or a pleader, it is impending upon you or people like you or students like you to create awareness program. I would always say to my students or to my juniors in the courts that the pleaders, the law students and the legal fraternity are the conscience keepers of the society. So, when I say that you are the conscience keepers of the society, you have to understand that certain laws which have been here for promoting good things in the society, you should take it upon yourself and try to bring upon awareness programs, okay, to the needful. And young legal professions like you can play a key role in promoting reproductive justice by raising awareness, providing legal aid and engaging in public advocacy. You have to initiate a public speech, public discussion on these type of things, so that it creates an awareness. They can educate communities about rights under the MTP Act, DV Act and the PCPNDT Act, support survivors and help them accessing remedies, and work with NGOs or policy groups to push for reforms by conducting workshops, campaigns and research. These are some out of so many what you can do to the society. Young lawyers can bridge gap between the law and society. Their involvement strengthens. So, the people like you should be involved in all this, and your involvement strengthens accountability, empowers the women of our country to claim their rights and contribute to the culture where pregnancy related violence and reproductive coercion are legally and socially challenged. So, I would suggest you should take it upon yourself and try to do your own bit in this particular subject.
Thank you, sir.